All right, in this video, we're going to dive into contracts and legal considerations for event businesses. Contracts are one of the most important tools for managing the relationships with performers, speakers, vendors, and the venues where you're going to host your events. We'll go over essential contract clauses, intellectual property, and the specific legal risks associated with running events. So let's dive in. Contracts are essential for setting clear expectations, protecting your business interests, and providing a legal framework in case of disputes. A well-drafted contract can prevent misunderstandings and provide a reference if things don't go as planned. I highly suggest you hire an attorney to at least review your contract templates, if not write them for you, depending upon your budget. This is not an area to be cheap on, as if a problem arises, you'll have wanted a solid contract. There are a few key clauses you'll want to include in contracts with clients, vendors, and venues. These clauses define each party's responsibilities and clarify terms, so everyone is on the same page. First, the scope of services clause. This section clearly outlines what you or your supplier is responsible for delivering. Include specific details such as the services, timelines, deliverables, and any limitations. If you're planning an event, this might include tasks like event designing, on-site coordination, and setup. The more detailed this section is, the better. It helps manage client expectations and ensures that they understand exactly what's included and what isn't in your services or your vendors. Next, let's talk about payment terms. This clause specifies the total cost, payment schedule, and accepted payment methods. It should also detail any deposit requirements, final payment dates, and cancellation fees. For instance, if renting a venue, they might require a 50% deposit up front, with the remainder due before the event. A cancellation policy can help you cover your time and costs if the event is canceled on short notice. Cancellation and force majeure clauses are also essential. The cancellation policy outlines the consequences if the event is canceled. Typically, this includes retaining any deposits or requiring payment for costs already incurred. The force majeure clause covers unexpected events beyond anyone's control, so think of natural disasters, pandemics, government restrictions, these kinds of things. This protects you if you're unable to perform due to circumstances beyond your control, giving both parties options to reschedule or terminate the contract without penalty. Liability and indemnification clauses are designed to protect you and your business. Liability limits your responsibility for any damages or injuries that may occur during the event, and indemnification protects you if a client or vendor takes legal action against you. Be sure to specify your limits of liability, especially if you're working with high-risk elements like pyrotechnics or large equipment. It's a good idea to work with a legal professional when drafting these clauses to ensure that they meet your specific needs. If you create unique content, like logos, event designs, or marketing materials for a client, you'll want to include an IP clause to specify ownership. An IP clause typically states whether you retain ownership or transfer rights to someone else. For instance, if you design a custom logo for an event, you may want to retain ownership but grant your suppliers a license to use it for that event. The key is to maintain all rights to your event and brand and not allow a supplier to lay claim to any portion of the event, including its brand, name, or customer base. Another key clause is the non-disclosure and confidentiality clause. This ensures that any sensitive information, such as budgets, guest lists, or vendor details, stays private. This is especially important when working with high-profile performers, speakers, or comedians, and at corporate events. The confidentiality clause protects both your business and your partners who you're working with, establishing trust and preventing the spread of proprietary information. When working with suppliers and venues, consider additional clauses tailored to these partnerships. These could include agreements on setup times, access to facilities, and responsibilities for damages or losses. For suppliers, include a clause specifying when and how they're paid, as well as any penalties if they don't fulfill their end of the agreement. With venues, you'll want to ensure there's clarity around event space usage, access times, and any shared responsibilities for security or cleanup, for example. Now let's look at some event-specific legal risks to be aware of. Events come with unique risks that vary by location, audience, and type. Here's how to minimize some common risks. First, make sure you have the necessary permits and licenses for your event. Depending upon the location and nature of your event, this could include permits for serving alcohol, food vending, or holding outdoor gatherings. Check your local regulations well in advance to avoid last-minute issues. Failing to secure the right permits can lead to fines or even a complete cancellation of your event. In some cases, it's also wise to have liability waivers, especially for events with physical activities or inherent risks. For example, if you're hosting a concert with a large crowd, you may have attendees sign a waiver acknowledging the risks of attendance or include it on the ticketing terms and conditions. Ticketing systems like PromoTix can require the attendee to check a box accepting your terms and conditions to purchase tickets, where you can insert a release of liability. These waivers can help protect you from liability in case of injuries, though it's important to work with a lawyer to ensure the language is legally binding, and it doesn't negate the need to have insurance. To wrap it up, consider working with a lawyer familiar with event planning and contract law. They can help you draft contracts, review vendor agreements, and advise on local regulations. This expertise can save you time and reduce the legal risks in the long run. You will be glad that you had it if you have a problem. Investing in proper legal support early on is a proactive step that helps prevent legal issues and gives you peace of mind as your business grows. Contracts and legal protections are crucial for running a successful and secure event business. By creating clear contracts and addressing key legal considerations, you're building a foundation for smoother operations and better partnerships.